Welcome back. We're now into the final part of Citizen Extra today. A day before Jamhuri Day. It's very interesting. Jamhuri Day had promised to become bigger than just Jamhuri Day. There was that expected swearing-in ceremony that has now been postponed. But before we get to Jamhuri Day today, something else of note is happening at the Supreme Court this afternoon. The judges of the Supreme Court are giving their detailed justification for their reasoning in that judgment where they upheld the election victory of Uhuru Kenyatta on October 26th, 2017. Now, some of the issues coming up: what happens when a candidate withdraws from a presidential race? What is expected to happen after that? Does a repeat election require fresh nominations to be carried out? What happens in case of an election boycott in some places, as happened in the four counties of Siaya, Migori, Kisumu, and Homa Bay? Yes, at least 25 constituencies did not participate in that election. And can voter turnout affect the legitimacy of an election? Remember, the voter turnout was 38.8% on October 26th. Now, these are some of the issues that we expect. If I missed one or two, probably you could correct me. But of the four, which one stands out for you as a lawyer? Which one do you think will have was probably the driving force for the Supreme Court in that judgment they made?
I think all of them are very, very critical. Sadly, the issues that are being dealt with are those which are not expressly provided for in the Constitution or the election laws. And for jurists, this is where really serious issues come up, and you will be looking at the Supreme Court struggling because their role is to interpret the Constitution and the law. And where a law is not expressly provided, we always say that judicial officers do enact law in the name of interpreting it. And this is where you will be seeing...
And so pronouncements by the Supreme Court automatically
become the law.
Yeah.
And that is why I say that we expect that our legislatures will be critically looking at the lips of the Supreme Court judges, and where they pronounce themselves in a manner that makes sense and meets the expectations of the citizenry. We expect that the legislatures will move quickly and create a law that resonates with that kind of interpretation of the Supreme Court. And more importantly, for the NASA team, who withdrew their candidate on an obiter pronouncement of the 2013 presidential election petition judgment, that if a candidate dies or abandons an election, then we go for a fresh election entailing nomination. I'm sure they will be looking at what the Supreme Court will be talking about in respect with that. And in terms of abstention of certain sections, because the Constitution is very clear, a presidential election must be conducted in 290 constituencies. Where some constituencies have not participated, what happens? Does other externalities negate that express provision of the Constitution? Yeah, that we look upon the Supreme Court to render its opinion on that, and really it is a turning point for the country, and this is why, in my view, I really should have expected NASA to participate in this election so that they give their input before the Supreme Court renders its decision. Now, sadly, their input and their able lawyers was not brought on board. In my view, the Supreme Court is all the poorer in whatever pronouncement they are going to give in the absence of that contribution.
Yes, because definitely NASA believes that some of its actions were right, based on the letter of the Constitution, probably in as far as the legitimacy of an election, if not all the constituencies took part in the election, because at least that is one of the things that is expressly provided for. The others, you may say, probably the pronouncements of the Supreme Court will be key. But on that particular one, if at all the Supreme Court says that yes, despite the 25 constituencies not taking part in the election, this election was still legitimate. Do you think that that's something that NASA going forward would want to challenge, that probably even in terms of legislation, because you have legislators, that you would want to make that more express, that all the constituencies have to take part in the election?
Let me first accept the compliment from Council Mogaka. Yeah, indeed, which is true that NASA has a tyranny of minds, legal minds. It has some of the finest in this country, and you used the words that some of NASA's positions or decisions were right, not some, all.
Well, that's debatable.
Yeah, but because you asked me, don't I think that some?
Okay.
So it is I talking, not Gabriel, and not even you. It's I. Okay. I'm telling you that the positions NASA took with regards to participation or not in the fast that was happening on 26th are still decisions that we believe are grounded on law, the Constitution, logic, and integrity, and they are correct. And we still haven't vacated those positions, by the way. There's absolutely no regret, because the basis was not just the law. In fact, it was much bigger than the law. When we looked at the law in terms of the requirement for fresh nominations, it was to see whether there was a way out to give the nation time for people to sober up, not for the sake of NASA alone, for people to sober up so that a proper election could be organized based on that one aspect of the law. But the bigger reasons were the intelligence, which turned out to be extremely factual, of course, of the capture of the IEBC and who were the people who were really running the IEBC and managing this election. The moment we had that information, and we shared it very widely, we knew that it's not going to happen. Forget it. There's no way, absolutely no way, there was going to be anything called an election that meets the demands of the Constitution and the law. And it didn't happen. So yes, the Supreme Court legalized the so-called election of President Uhuru Kenyatta, but will never legitimize it.
Would you challenge any of the pronouncements made today? Because of course you disagree with the Supreme Court legalizing that process.
Well, challenge not at the Supreme Court, but challenge in the court of the Kenyan public.
Yes.
That even in the political on the political scene.
Yes.
That I've told you that even the court, I'm sure there are some things itself may not want to muddy its hands too much, maybe pushing some of those things back, either to Parliament or even just to SAT in general. And there is where we are best prepared, because we know that the fight we had is not limited to a legal fight. That was a very tiny aspect of it. And that's why we never worried, we were never bothered. And especially after seeing the intimidation that the Supreme Court came under from the executive, from Uhuru Kenyatta himself and the rest of the people in Jubilee, but particularly from the person then who was an incumbent president in charge of the executive. We knew that it's not even a place to hop in. The fight must continue as a political fight, but of course, as society, we anchor it in law. So yes, some of the provisions we will have to wait and see, but some of the provisions, as we did with Willie Mutunga's court, eventually many people agreed with then it was court. Initially arguing, no, you must accept, but eventually many people agreed that this is challengeable, that this was shoddy. So we will, in this public space where we are pushing for this larger fight, we will, if things come out that need to be challenged, we will challenge them but not saying that we've come back to the Supreme Court and we're telling you, review your decision, because we were not party to that those petitions.
Yes, and indeed some of the pronouncements could be challenged. Would you really be part of that, given that things went your way? But even then, if a pronouncement by the Supreme Court does not really agree with everything that you aspire to, even Jubilee should be keen on challenging some of those things, don't you?
Well, yeah, but you also have to remember, and before actually I think it is quite overreaching when somebody says they have anyway we still end up losing, but it's still it's
an admission actually from a member of Jubilee.
I've always argued the greatest threat to knowledge is not ignorance. It's the illusion of knowledge, thinking that you know, but you really don't know, and that's why you end up losing. And you not only lose, you are in a dilemma. You become planless. Nothing you try coming up with works. You know, and the minute you start thinking that, you know, you own the mechanisms of righting everything that you think is wrong, I'm telling you, you'll end up losing. I was putting it to another legal mind, and I told him, you know, he was arguing that you are as brilliant as they come. And I told him, how many cases have you lost? And he said, I've lost several. And I was asking him, does that mean you're not as smart or as bright as you think you are just because you lost? No, you have to realize that some of the things which you see, others don't see them like that. You may actually be wrong, but you still have an illusion that you're right. And so heading toward the, you know, the comprehensive judgment that will come out, I told you I'd like to see some of the things. You remember when the election was nullified, and people said, you know, President Uhuru threw a tantrum. He may have done that, yes. But at the end of the day, he had to go and actually respect and adhere to what the Supreme Court had asked, and to repeat another election and be part of it. And albeit the fact that he, you know, he had lost, you know, he was beat, he had actually to gather himself up, him and his deputy, and they had to go back to an election. So you had NASA on the other side saying they had the tyranny of brains to boycott an election, and thereafter try to play around with the articles, you know, of our Constitution 138, which did not favor them at that time. And mine probably what I would like to see, because really this particular area will actually put into context how we will go into elections come 2022. Okay. And this is the element of boycott and creating uncertainty in an area, so that, whether be it a word or a constitution, so that that can be called off. I think that is where I want to train my sights to. Okay. Because I argued, and I'm arguing again here, if that is not well captured, many people are going to use that as an escape route, where you know very well that you can create a scenario when you know you are losing, and say an election did not take place. Okay. So I think that is where I want to train my sight.
Let's now look at the Supreme Court.
Pardon 1 minute.
Yes.
Could you please give him time now to answer your question?
He totally ignored it, and I think I've moved on from that.
Possibly he wasn't able to answer it.
That question has already been answered. My good friend actually answered it. There is no need of me repeating it again.
Okay.
He's answered it quite well.
Let's talk about the Supreme Court now, and the bench as currently constituted. There are issues of perception that the two gentlemen have mentioned, issues to do with the fact that the Supreme Court, after the applause they received after September 1st, they made that judgment nullifying the election of the presidential election of August 8th, and they received quite some applause from both within and without the country, outside the country. They were praised as being revolutionary, the first Supreme Court in Africa to actually nullify a presidential election. But after that, that perception appears to have changed, because yes, the people say the court is now intimidated, they were subdued, they started following party lines, and we saw that issue a day just before the election, where they could not even be able to get the proper quorum to attend to a presidential election matter, and that raised quite some doubt in the capability of this bench. Don't you think that they are under even more pressure this time around in giving today's justification to actually disprove that, to actually show Kenyans that yes, whatever judgment we made was based on the law?
Thank you. Yes, perceptions are perceptions, and they are always in the beholder's eyes. One correction I want to make is that the applause the Supreme Court received after the 8th August election was no more than the condemnation it received from the other side of the divide, no less than the respondent then, the president-elect whose election had been nullified. So while the Supreme Court was celebrated, there are those who believed that that kind of decision was not warranted, but that is for another day. The most unfortunate occurrence about the Supreme Court is that moment that it did not marshal quorum to deal with a very critical application by a citizen. Indeed, at that particular time, the very critical petition that was before them was not heard, and it was about stopping an election that was happening the following day. I don't think the Supreme Court will reclaim or redeem itself from that particular incident, and I don't think the explanations that were given were convincing, particularly to the litigants. But that is now water under the bridge, because since it targeted stopping an election which has now occurred, really we can only be crying over spilt milk. Be that as it may, the petition on the 26th election, which is really what we expect the full judgment to be about, is about the constitutional provisions, the law, and the particular activities that occurred that militated against what one would call a conduct of a free and fair election, and against, it's the facts against really the law and the circumstances under which that election was conducted about. I expect that on that particular area, I expect that the Supreme Court will acquit itself on their pronouncements, because they really don't have a choice but to deal with the Constitution, the fact complained about, and the evidence that was brought before them. That is why I'm saying that if NASA, whose candidate withdrew, participated in this particular petition, then perhaps their complaints would have been brought on board, and then we would have seen what the Supreme Court would pronounce in view of that. But they were not there. Yeah. And it is also sad that among the constituencies or counties that did not participate, again, fall within a certain political divide, who were not on board in this particular election. That is why I say the Supreme Court, given the facts and circumstances, will pronounce itself, but their decision will really be all the poorer compared to if this particular grievance were brought on board and brought their side of the story.
Simewa, of course, even for NASA, because you whatever you're pushing for is for the greater good of the nation. You would want a stronger Supreme Court, a stronger judiciary. You applauded the kind of tenacity that court had when it made that judgment on September 1st. After that, things have changed, and NASA has criticized that same court of being manipulated, of being cowed, of being threatened into submission. But don't you think that even for NASA, you're keen on having the Supreme Court and the judiciary as a whole redeem itself from that kind of perception, that they should come out and reclaim the kind of position they had before all these things happened? Do you think they have that opportunity today?
You know what, knowing the role of the judiciary in Kenya, even as we protest the weaknesses they are in, the unfortunate position that sometimes the judiciary has found itself in, we have never lost sight of the fact that we are still subject to the authority of the judiciary of Kenya. That doesn't deny us the right to criticize where we see wrong, to say, you know, you have been captured. It doesn't deny us that right. We have never at any one point purported to say that we are removing ourselves from the jurisdiction of the judiciary of the Republic of Kenya, and neither have we ever said that the judiciary must abdicate its responsibility. We will criticize, but we do not lose our right to make demands on the judiciary. And that is why, Fred, one of the petitions, this is Khalef Khalifa and John Jomoe, had enjoined NASA as a respondent. And respectfully, even though we were never party to the so-called election, respectfully, the NASA legal team had comprehensively responded. You know, it had no choice. It obliged. It didn't go there to protest that we don't want to be responded, because of the respect of the institution of the judiciary, and exactly what you are saying, that even as we disagree, our participation in this process has then strengthened the judiciary, the jurisprudence, the environment that we seek to correct. We contribute through that. But immediately Uhuru Kenyatta's lawyers saw our response, they panicked. Uhuru Kenyatta and IEBC completely panicked. And they went to the court saying, no, remove NASA from this petition. And unfortunately, or fortunately, depending on how you look at it, NASA was removed as a respondent. But exactly what Mogaka is saying, NASA had prepared a response on the basis, of course, of the petition by John Jamwe and Khalif Khalifa, giving out its side of the story based on fact, knowledge and fact of what had happened. But
so you still have faith in the Supreme Court despite the happenings that you criticized?
Do not twist my words. I have told you, even when we lose faith, what we know we have never vacated the position of the
lost faith.
Legitimate jurisdiction of the Supreme Court over the Republic of Kenya, which we are part of. Secondly, by criticizing, by pointing out where it's been captured, we do not lose our right to place demands on the Supreme Court and any other organ of the judiciary of the Republic of Kenya. So there are things we will see and will be unhappy and will point out.
Do you think any of the pronouncements they make today have the opportunity to having you change your mind with regard to how you perceive the court?
You see, you look at case by case. So let us not use one case to make a blanket decision. We have been very specific on our criticism of the judiciary. In fact, particularly the Supreme Court, we've not so much as laid the blame on the Supreme Court itself. We've laid the blame elsewhere.
Okay.
Where we've laid the blame directly on the judiciary on the Supreme Court is particularly with regards to the 25th, when horrendously they failed to raise quorum. Unacceptable anywhere. It's as if they do us a favor when they sit to preside over cases. It's not a favor, it's an obligation they have. A duty, not to NASA, a duty to the nation, to the Constitution, to the citizens of Kenya, and they failed us. We laid blame squarely on them. But we knew the facts we had that was engineered from elsewhere, but they ought to have resisted. So please get my words correctly, not to say just a blanket that have you no faith or not in the judiciary. There are things we've pointed out we are unhappy.
Okay.
There are things we have pointed out we are happy. It doesn't take away our obligation to respect the jurisdiction of the Supreme Court of Kenya.
That applies to
doesn't take away our right to make demands for the Supreme Court of Kenya.
Yeah, that's
things that you're happy with, some you're not happy with.
That one I agree with, even to the extent of criticizing the Supreme Court, and actually, any other court, whether upper or lower. I mean, that's the right feeling that you have. Fred and Wakili Mogaka here would tell you, I've never seen somebody happy when they lost a it's certainly, there's that element of humanity in you that, it will grasp you and say, I've lost unfairly. And it happens. But that does not mean that you will not live up to the credibility of that particular court. You can come out, mess around, say what you have to say, but at the end of the day, you must be able to have reason enough to continue respecting that code which has actually been put there by the sovereignty of our Constitution that we all agreed was the only instrument that brings us together. Having said that, let me finish by saying, as we are moving forward, yes, I would like to see a stronger Supreme Court. I would like to see a Supreme Court that is less interfered by anybody, not the government, not the opposition. I'm talking about anybody and everybody. We need to leave them at the masses of the Constitution because they know what they are doing, and we need to give them that, that faith. Same way as it applies to every other independent institution, IEBC is one, and I think we can criticize it as much as we want, but interfering with independent institution must become a thing of the past.
Final word on this, Stephen Mugabe.
Yeah, final word on this is I know that the decision today will be jurisprudentially poor because it is a unanimous decision. Scholarly minds in law would be wanting to look at how each judge applies their judicial mind to the various issues that are being determined today. But since it's a chorus, unanimous decision, I think the scholarly minds will not find the judgment exciting, but it is a judgment of Supreme Court all the same. It binds the Republic of Kenya, everybody in equal measure, and we hope that this will elevate our country to a higher pedestal as we go forward.
Thank you so much, Stephen Mogaka, lawyer, Joseph Simeta, NASA strategist, and Gabriel Muduma, Jubilee strategist, for helping us get through those very interesting discussions this Monday. Time now for a break, but Citizen Extra is not over yet. After this break, Brian Okoth will be in studio with views on the news. Do not go anywhere.
Thank you.
Have fun.